During opening argument, can I call jurors individually by their name? You want to know the answer and why it's an important question? Come join me for a moment as I walk on the beach and tell you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say you sued your doctor for medical malpractice, claiming that he caused you harm and injury. The doctor disputes all of your claims and he says, screw you, I'll see you at trial. Okay, so now 2 or 3 years later, your case finally comes up for trial. When it comes up for trial, now we begin the trial. And during opening arguments, I have an opportunity to talk to the jury and explain to them for the very first time exactly what your case is about. I have a chance to tell them in detail the facts of your particular case and why we believe we're entitled to a verdict in our favor to show that the doctor was careless and that his carelessness was a cause of your injury. Now, admittedly, it's a one-sided conversation. I'm explaining to the jury why the proof and the evidence that they're going to hear supports our version of the events to establish that yes, the doctor was careless, yes, his carelessness was a cause of your injury, and yes, your injuries are in fact significant and permanent. Imagine how cool it would be if during the course of my opening argument, I could turn to juror number 1 and say, Mrs. Jones, I want you to keep an open ear for the expert who comes in to testify, who's going to say that this doctor violated the basic standards of medical care. And now I turn to juror number 2 and I say, Mrs. Gold, I want you to listen very carefully to what the doctor whom we have sued is going to say about this particular issue and why we believe he lied, and we're going to show you that he lied. And then I turn to juror number 3 and I say, Mr. Gonzalez, pay attention to what this next witness is going to talk about. Can I do that? The answer is, I probably could do that, but I'll tell you, in almost 30 years of practice in New York, I've never heard an attorney do that. And I think if I did, the judge would clearly yell at me. My opponent would get up and object. Why? Because they would know what I'm trying to do. So what am I trying to do, other than trying to be friendly and create a bond with each of the jurors? What I'm trying to do is to get them to become familiar with the facts of the case, to get them to recognize me as someone who is a friend. But it also forms a bond. So every time you use somebody's name, now they pick their ears up because now they realize, hey, you're talking to me. They're not falling asleep or thinking about something else. Instead, they're saying, hey, this guy's talking to me. He's focusing on me and my concerns and my issues and things that I'm going to be thinking about on this particular case. The judge is not going to allow it. The defense attorney is going to object, and the judge is going to yell at me if I do in fact do that. So why do I share this information with you? I share this with you because very few people actually address this issue when giving information about how these types of cases work. And I thought it would be helpful to you, especially if you're searching for information about how these cases work and you're thinking about bringing a lawsuit, but have not done so yet, and you need your questions answered, then what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day if your matter happened in New York, and I invite you to call me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.